This is another ridiculous example and therefore another video of why we don't really have free speech in the UK at the moment, despite Keir Starmer's insistence otherwise, unironically with Donald Trump in the country, and with this story being about an American visited by the UK speech police. So let me show you the video first, and then I'll talk about the law once again, because I think it is absolutely vital that everybody understands what the law is. And of course, this can't be particular legal advice to any one situation, but very broadly, I will tell you what the law is so you know if you get a knock at the door. But first of all, watch this video. It's outrageous. Watch this.
You can come in, but you better have a damn good reason for being here. I'm a member of the Free Speech Union, and I'm an American citizen. I'll have Elon Musk on you so quick your feet won't touch.
Something that we believe you've written on Facebook has upset someone.
You're here because somebody got upset. Is it against the law? Am I being arrested?
You're not being arrested.
Then what are you doing here?
My plan was, if you were admitting that it was you who wrote the comment, you could just make an apology to the person.
I'm not apologizing to anybody,
Well,
I can tell you that.
The alternative would be that I have to call you in for an interview. I'm here to talk to you about the allegation. They've reported it to the police.
So what?
Obviously, we get a lot of reports like that.
Are there no houses that have been burgled recently? No rapes, no murders?
Yeah, that's all going on as well. That's been
Well, then why aren't you out there doing, investigating those?
Because I've got to investigate everything that gets reported.
Well, you're not investigating houses being burgled.
No, that's not my job today. Would you like to have a look at the comment that I'm...
I don't need to. I know exactly the things I've said. You know how many people in this neighborhood have been broken into?
I don't look after this neighborhood.
No, of course you don't, unless there's a tweet, then you do. So what? I haven't broken any laws. So you're going to be wasting your time when you can be, instead, doing things that are more important.
That's why I wanted to just come to you directly, have a chat about it.
No. You should not be doing this. I'm a cancer patient. You can see that because I'm bald.
I didn't know that before I came, but it doesn't change anything. You still can't break laws. If you haven't broken a law, then nothing happens.
Well, you know whether I've broken a law. You can judge for yourself before you even show up at my door. The public knows what you guys are doing. We know what's going on in this country. Why don't you do that? Get onto them and tell them to apologize to me, a cancer patient, a woman living on her own, who has never broken a law in her life, by the way, ever. An older woman, you tell them, I'm an elderly woman, I'm a cancer patient.
I have to come back and arrange an interview then.
Well, you can arrange it, but I'm going to tell you the same damn things that I'm telling you now. Next time, I'm going to have a Free Speech Union lawyer with me.
And as it turns out, the Free Speech Union did intervene, and now Thames Valley Police have said that they are dropping the investigation. So let me tell you the details of this story from Free Speech Union here. An American cancer patient and Trump supporter was confronted by British police and told to apologise for her online posts, all face an investigation, which in my view is a bit of an abuse of power. You cannot say you must apologise or we'll investigate you and maybe prosecute you, because that's not how it works. Because even a court would not order somebody to apologise. Let's read on. Deborah, a mother of two, was visited at her home in June by an officer of Thames Valley Police. He told her someone had lodged a complaint about her social media posts. She told him she was an American citizen and a member of the Free Speech Union, and he should be investigating burglaries and rapes, as you just heard, not hurty words on social media. Chillingly, he told her that he was there to get her to apologise to the person who was offended by her posts. Now, as an aside, which I will come back to, but causing an offence, as I've said many times before, is not an offence. Reading on. If she refused, she'd be questioned down at the station, which is why I think it's an abusive process. What was Deborah's supposed crime? The policeman didn't tell her. Was it her passionate support of President Trump and the MAGA movement on her Facebook and X pages? To make it worse, Deborah's in the midst of cancer treatment, including chemotherapy. She ought to have been convalescing. Instead, she was harassed for her tweets. The Free Speech Union took on her case, and as a result, the police have now dropped the investigation. But they still haven't told Deborah which of her posts got her into trouble, claiming they've accidentally deleted the record of the complaint. Now, to be fair, it did sound like the officer was about to say, do you want to see the tweet, or do you want to know what it was? And that didn't come out in that video, but now apparently they've deleted the record by accident. I doubt it, frankly. I think that's a little bit silly, or at worst, careless and irresponsible. Take your pick. Thames Valley Police are responsible for guarding President Trump this week. What would he make of the fact that those same officers are visiting the homes of his supporters, including US citizens, and threatening them with arrest? Now, as I said, I think this is an abuse of power. Now, I haven't seen the tweets, but there is probably no crime here, because it would have to be really, really serious for a tweet, a post, to cross the criminal threshold. Now, this has been to court, even had a judge convict somebody of posts and tweets and things like that, which were apparently they believed to cause annoyance and some alarm and distress to somebody. But the High Court said, no, this doesn't cross the criminal threshold. One such case, which is one of the leading cases on this, is Scotto and the CPS, and this was at the High Court. Now, I've mentioned this case many times before, but it absolutely needs repeating here, and there's a little bit that I haven't mentioned before in this case here. Now, first of all, this case references a prosecution under Section 127 of the Communications Act, which is a person's guilty of an offence if, for the purposes of causing annoyance, inconvenience, or needless anxiety to another, they send a message or cause a message to be sent or make persistent use of an electronic communications network. Now, when looking at that, it has to be read very, very carefully. Something has to be done, sent, or made use of for the specific purpose of causing annoyance, inconvenience, or needless anxiety to another. So, for example, choose a choice word or phrase that you think would cause needless anxiety to somebody, something really horrible, and you sent that to their phone or their email or posted them online and atted at them online every day for the sole purpose of annoying them and causing them distress. Let's say they have a protected characteristic, and let's say that your insult was directed at their protected characteristic, and you sent it every single day on the dot, 9 a.m. or whenever, every single day for a year. That would be persistent use of a public communications network, sending something quite easily, arguably, for the sole purpose of causing needless anxiety or annoyance to someone else. And probably several other offences as well, but let's leave that aside. Looking at this type of offence, that would much more likely be prosecuted under this section. Now, posting something that someone finds annoying, finds offensive, gets disturbed, has anxiety, finds offensive, or is some way or other insulted, condemned or attacked or whatever, all those things, they do not cross the criminal threshold for the purposes of this law. And that is precisely what the court addressed here. The court said that any prosecution under this section is plainly an interference by the state with the Convention right to the freedom of expression, which is not an unfettered right. In other words, the state can interfere with your right to the freedom of expression, and it does so if you cross the criminal threshold, not for sending annoying tweets or just a tweet that annoys somebody and it just happens to upset somebody. Now, the bit in pink here, if I make it even bigger, you can probably see it even better. The bit in pink is the original court's decision where they convicted on this offence. And the judge said as follows: in considering your evidence, I've reminded myself of Article 10 and accept fully an individual's right to free expression and the right to take part in public debate, and that Twitter, as it then was, is used by many people for that purpose. However, Article 10 rights are not unfettered, and I do not find your communications to be part of a debate. They are merely personal comments aimed at Miss Hayden. Now, pausing there for a moment, it doesn't need to be part of a public debate. That's just not part of the requirement. So, reading on. We teach our children to be kind to each other and not to call each other names in the playground, and there is no reason why, simply because something is on social media, we shouldn't follow that same rule as adults and think about what is being written before sending messages and not send stupid throwaway comments as described by the person in this case. The judge then said, I'm asked by your counsel not to criminalise Twitter and shut down free speech. That is not my intention, the judge said. There should be no restriction on proper debate, but I do not find that what you did was furtherance of any debate, as I hope I've explained. Now, as I've explained, making this video for you, proper debate is not a requirement. You can send something that is just annoying to somebody, save where it crosses the criminal threshold. In the example that I've given, where if you sent something really heinous to somebody, attacking somebody's personal character or protected characteristic, it doesn't need to be a protected characteristic or whatever, but persistently every single day, doesn't have to be every day, but persistently over a period of time for the sole purpose of annoying or upsetting that person, then that might be different. And that is obviously then potentially a form of course of conduct forming harassment as well. But then the High Court here, which quashed this conviction in the end, said as follows. This is an unstructured, referring to the judge's comments, this is an unstructured approach that lacks the appropriate vigor. The Crown evidently did not appreciate the need to justify the prosecution, but saw it as the defendant's task to press the free speech argument. The prosecution argument failed entirely to acknowledge the well-established proposition that free speech encompasses the right to offend and indeed abuse another. So you can have these conversations online. You have the right to offend somebody. You have the right to abuse somebody in that conversation. It doesn't matter unless it crosses the criminal threshold, which these usually don't. Judge went on. The judge appears to have considered that a criminal conviction was merited for acts of unkindness and calling others names, and that such acts could only be justified if there was a contribution to proper debate. But neither prosecution nor judge considered whether some more demanding interpretation of Section 127 or addressed the question of what legitimate aim was pursued, or more importantly, whether a conviction of this defendant on these facts was necessary, and whether it was proportionate means of responding to some pressing social need. Now, reading further down, the court ultimately came to the conclusion that this was not an offence. Judge said, in short, I do not consider that under Section 127 there is an offence of posting annoying tweets. I would reach that conclusion as a matter of domestic statutory interpretation, without reference to the Human Rights Act, which encompasses Article 10. But once one takes Article 10 into account, the position's even clearer. So just to restate that for emphasis, a lot of people are saying, if we lose ECHR, we lose the right to free speech. No, we don't. And we don't lose the right to life. We don't lose the right to not be tortured. We don't lose the right to free speech. We don't lose the right to privacy and family life and religion and all these kind of things. We don't lose those things. We had those things before ECHR. We will have them if we repeal it, by way of repealing or replacing or amending the Human Rights Act. But the judge said here, even without reference to those rights, judge said, I do not consider, under Section 127, there's an offence of posting annoying tweets. And that is as a matter of domestic statutory interpretation, without reference to the Human Rights Act. But once you apply that, it's even clearer. For these reasons, and those given in the judgment of Justice Warby, with which I agree, I would allow the appeal and quash the conviction. So there is no offence of posting annoying tweets, or even those that abuse, offend, cause offence. It doesn't need to be proper debate. They can annoy somebody. You can send something which is offensive, and that itself is not an offence. So when you have the police coming around and threatening to demand an interview of somebody if they don't apologise, that essentially, to me, that is an abuse of power. It's an abusive process, because they are saying, unless you apologise, we are going to make your life hell by bringing you in for interview. That is wrong, that is abhorrent, and it should not happen. And if anything, it's Thames Valley Police that owe this lady an apology. And for that matter, I think they owe Donald Trump an apology by way of extension, because one of his citizens, his supporters, is here making us look stupid, whilst Keir Starmer is saying, we have free speech, we've had it for a long time, we're very proud of it, and we maintain it. This is proof that that is very much not the case sometimes. Because just by taking these actions, I posted a poll some time ago, how many people have deleted something before posting it because they're worried about being arrested? Lots of people did. If I have the statistics, I'll put them up on screen. And for that reason, I am a member of Free Speech Union. I'm a gold member, which is a bit more expensive, but for overseas members, it's just $39.99 for US citizens, and for everyone else as well. If you value free speech, this is not a sponsored video. They've not asked me to do it. I've not told them I'm doing it. I'm a member because I believe that it's the right thing to do, because my fees will help somebody else, and we all never know whether we need some help now and again. And Free Speech Union is here to defend and protect free speech. And I see here you can also gift membership to somebody else as well. You can check that out as well. And unfortunately for this officer, I think he's being made to be a bit of a puppet for the system to go out and harass people for things they posted online to try to stop people saying nasty things. I think it's quite ridiculous. I think it's embarrassing, and it needs to stop. So hence the video, so that you all know what the law is. So if you are visited by the police, you can produce this for them. This is not legal advice, you understand, but you can produce this. I'll upload this case with my highlights to my website, BlackBeltBarrister.com. You do need to register, but you don't need to pay anything. But then you can go to the download section. You can download it there. And I suggest that you have this with you. Read it. It's very interesting, and it will tell you what the court said about free speech, as I've highlighted some of the main points here. So with that, let me know your thoughts and comments in the box below. Please do subscribe to the channel. That's free. It's just a big red button below. Hit subscribe. Thank you so much. I'll see you next time.